The First District Court of Appeals is back in session.
All right, good morning. The final case on our docket this morning is C-24-0626, Edelstein versus Edelstein. I see that both parties are present, and I assume ready to proceed. Ms. Edelstein, you are the appellant in this matter. You have 15 minutes to argue, which you can divide as you choose. Mr. Edelstein, you have 15 minutes to argue, which will be at one time, and we'll hear you in the middle. Just a few ground rules for this morning. Please keep your microphones muted when you are not speaking so that we can avoid any background noise. For timing, I will give you a 1-minute verbal warning. And when your time has expired, I'll give you an audio warning as well as a hand signal to let you know that your time has expired. All right, Ms. Edelstein, you may begin. Would you like to use any of your 15 minutes for rebuttal?
If it please the court, I'd like to reserve 2 minutes for rebuttal.
All right, and you can begin when you're ready.
Thank you. This case has 3 significant procedural errors that I need to alert the court to. One of them is insufficient service of process. One of them is ex parte communications that are occurring between the appellee and the judge of the case. And the other one is the issue of exhibits that were not admitted at the trial level, but were admitted at the appellate level. The first thing I want to address are the ex parte communications. In Ohio, the Supreme Court has said that ex parte communications between a judicial officer and a party violate the right of the opposing party to receive a fair hearing. I asked the judge to recuse herself. She refused. When I complained about it in an affidavit of disqualification, she submitted an affidavit and had the magistrate submit an affidavit that had false statements in them regarding this ex parte communication. I have a recording where her voice comes in on the recording, and then I paid a court reporter to transcribe it for the appellate court. And in the transcription, that clearly shows a third person entering the hearing via an open phone line, yet both the magistrate and the judge told in an affidavit to the Supreme Court that nobody was there other than the magistrate. And this is one of the issues that I've been dealing with consistently with this trial judge. And so that is one of the procedural problems. The second one is the sufficiency of service. I received notice of this ex parte order through an attachment in a Franklin County case. So it was an exhibit in a Franklin County motion. That's how I found out about it. And my ex-husband made that a public record to embarrass me, even though it's a DVCPO and should be private and is not open to the public. The final order was also never served in accordance with Civil Rule 4 on me. Under Ohio law, the failure to properly serve is not a minor hypertechnical violation of the rule. It's an important step in obtaining jurisdiction over the person. The statute for a domestic violence protection order requires that the temporary order has to be served and that the final hearing has to be timely. And the statute gives 10 days, but it allows for a short continuance if necessary. But the final hearing in this case went on 6 months later.
Ms. Edelstein?
Yes.
So you, in this case, attended and participated in that hearing?
Yes, I participated in the hearing because, again, these are significant rights that are being restricted for me. And for due process, I didn't want to not participate. But again, as the Supreme Court says, I don't have to participate. I could have not. But this temporary order was on for 6 months, keeping me from my son, keeping me from having communications with him. And I had filed motions asking for a change of custody, and the judge ignored them, claiming she had no jurisdiction to
Well,
entertain those.
so in this
motions.
case, you were attempting to disqualify the trial court judge, correct?
Yes, I filed an affidavit
And-
of disqualification.
And recognizing that proceeding, she decided to continue the final hearing so she could get a determination about that. Is that a fair summation?
Yes, that was part of what delayed it for 6 months, yes.
And then when you actually had the final hearing, you showed up and had the opportunity to cross-examine and present witnesses, correct?
Correct.
Did
And
you ever file a motion to dismiss based on insufficiency of process?
I believe I did in one of my motions, but I can't tell you for certain.
And then also, this is in fact a special statutory proceeding, correct?
Yes, and Your Honor, if I may correct my statement, I moved at the hearing to dismiss.
Where is that in the transcript?
And I believe I moved for insufficiency of service, and it is I believe it is in the transcript. It was either a motion or I moved at the hearing.
All right. So
So
you believe that you verbally moved for a dismissal and not sufficiently raised dismissal because of insufficiency of process. Is that a fair summation of what you're asserting?
yes, I believe that's accurate, but again,
but if
the
you did not-
transcript is the best evidence.
But if you did not file a motion to dismiss or move the court to dismiss, do you concede that there was process based on your participation, or there was personal jurisdiction, rather, based on your participation in the hearing?
No, I would still argue that it doesn't waive the sufficiency of service of process. But
Thank you. Go ahead.
Okay, thank you. Then the final procedural issue was that, under the Supreme Court, a reviewing court can't add matters to the record that were not part of the trial court proceedings. I've been a magistrate for 9 years. The ex parte hearings are to prove good cause, to issue a temporary order and set it for a final hearing. It is not to take exhibits into evidence, and the magistrate in this case properly didn't do that. In fact, when Elliot asked if she wanted the exhibits, she said, no, you're going to have to bring them to the final hearing. He asked if he should file them. She said no. So they were not admitted at the ex parte level, nor should they have been, because there was nobody there to object to them properly. So again, that I moved for them. For some reason, when I contacted the court administrator about this, because I noticed it on the official record to the appellate court, she indicated that she would ask the judge about that. And then she told me, well, the magistrate admitted them. She did not. The transcript clearly shows that. So I filed a 9A motion to correct the record, and this court also incorrectly said that the magistrate admitted those exhibits. But those exhibits were police records, police reports, which are double hearsay. And there was nobody there to object to them, and there was nobody to authenticate them. So again, the due process rights have been violated because they should not have been considered or admitted. They were only to prove good cause to issue a temporary order. Again, they're double hearsay. So
Ms. Edelstein,
Yep.
back to my question about this being a special proceeding. This is a special proceeding, but I believe that the statute provides that the civil rules do apply. Is that your understanding?
yes.
Okay.
Now, may I continue, Your Honor?
You may.
Okay,
In this case, just to go back to that, this was a petition. There was no answer or anything that would be considered a responsive pleading. That's fair also?
Yes, that's correct.
Okay, go ahead.
Ms. Edelstein, I have a couple of questions for you.
Yeah.
I understand you to be raising some procedural concerns with regard to the ex parte hearing. To what degree does the final hearing on the final DVCPO moot the issues that you contend occurred at the ex parte hearing? Do you understand the nature of my question?
Yes, I think I do. So under the statute, the ex parte hearing and the final hearing are two separate events. And the ex parte hearing is governed differently than the final hearing. So at the final hearing, Elliot had the opportunity to bring exhibits and witnesses, but he failed to timely exchange them with me. And so the trial court judge excluded his exhibits, but she didn't exclude his witnesses. She allowed him to give testimony. So he gave testimony. And that was what was permitted. So those exhibits were not allowed even at the final hearing. So I never saw them because they weren't exchanged to me. I never had a chance to object to them because they were never moved or admitted or addressed. In fact, when Elliot tried to address them, the judge said, well, you didn't exchange them and the exhibits aren't in front of me. So they weren't part of the final hearing. But then when I ordered the record to go up to the appellate court on the notice of appeal, it listed his exhibits. And when I reached out to the court to ask about why are the exhibits included when they've been specifically refused from the final hearing, I was told that she checked with the judge and they were admitted by the magistrate. But again, the transcript shows that they weren't admitted. And again, due process rights allow a person to challenge evidence in front of them, and police reports, which are double hearsay, are a retelling from an officer from things he heard from Elliot, who's retelling his version of events. So again, it causes a whole bunch of procedural issues that they shouldn't be considered by this appellate court. And then when he was denied the use of those exhibits, he puts in his appellate brief text from those exhibits into his appellate brief. And I moved to have that stricken, and this court denied that, indicated that it will review what's appropriate, which I understand, but still procedurally, I think that's improper. His brief should have been stricken, but that would give him absolutely no basis for this. And I think that that's part of the issue. Now, substantively, I'd like to talk about the claim while I have some time left. And that is that there were I had left Indianapolis. And again, this coincides with the other case. I had left Indianapolis at the end of March. I was staying with friends in Cincinnati because now that my son was taken from me, I wanted to be closer to him in the event that I get visitation, because the statute requires I have continuous contact, but that didn't happen. So I was looking for a place to rent that was cheap in Cincinnati. And while I was there, I was around publicly, and I came in contact 4 times accidentally with my son, and none of those were intended contact. And then the 5th time, I didn't even see my son. I went to speak to the babysitter. But what happened is the first time I had inadvertent contact with him, I went to try to resolve this case with my ex-husband outside the court. He yelled at me, called the police, and then he proceeds to have a conversation with the police officer on a recording where he's trying to figure out how to get another DVCPO and set me up on it. And then the 2nd time, I went to my daughter's house, my adult daughter. I had no idea she was babysitting my son. I went there to talk to her about a personal issue on the advice of my therapist, and she got upset with me. But I saw my son inside the house. He was telling me through the door, asking me for help. He was being restrained inside. That caused me a great deal of concern as a mother. And I saw my husband manhandle him at the other time that I inadvertently came across my son. So I had concerns, and I appropriately approached the judge with motions, which were held in abeyance. Then I went to the synagogue where my son doesn't even attend. He attends a synagogue across town, and it was a costumed holiday. So I was in costume, and I went for services. And I specifically went there because I know they don't go there. And he showed up, and my son even testified he was surprised that I was there.
Ms. Edelstein, you have about 30 seconds left. Just want to give you a warning.
And the other instances were also inadvertent. And then, but seeing him hit my son's hand, manhandle my son, I was concerned about this. So I went to talk to the babysitter, and she locked him in the house and wouldn't, so I didn't even see him. But my son testified down the line supporting every version of events I gave to the court because I was telling the truth. And he even disputed Elliot's testimony, and the judge disregarded his testimony, saying he's of tender age. which is 7 in the state of Ohio. He was almost 13, and his babysitter and the court social worker said he was mature and intelligent. So the judge deliberately disregarded his testimony after she questioned his ability to understand the proceedings and truth from false, and she allowed him to testify. She didn't disqualify him under Evidence Rule 601. She allowed him to testify, but then she didn't like the testimony because it was supportive of me, so she
Ms.
disqualified him.
Edelstein, you're out of time. Thank you very much.
Thank you.
All right, Mr. Edelstein, you have 15 minutes to present your argument.
Thank you, Your Honor. May it please the court. Kimberly broke orders the day after the first DVCPO ended. She was waiting outside, which was February 27th, 24. She was waiting outside my apartment on foot, hiding and not showing her face until our minor child and I were at the front of the apartment door. That was the first major court order she broke after the first protection order was ended. After I threatened to call the police many times and then actually calling the police, she then walked away from the apartment complex to wherever she parked the car. She was ordered to stay away from our minor son, and if she needed time to communicate with me, she could have emailed. Instead, she decided to show up at my residence unannounced and disrupted the health, safety, and welfare and mental stability of myself and our minor son during a school night. This lasted approximately, with the police and with her showing up, from 6:30 to about 10:15 at night. Then 4 more orders were broken with the police reports that were self-explanatory. A total of 5 occurrences where Kimberly showed up unannounced to see our minor son and just cause havoc. She showed up at residents in Ohio, driving around, sitting around in her car, driving around at these various locations. All of these police reports happened within 6 weeks of each other, including letters to our minor child with disturbing messages from a mother to a child, clearly involving our child in adult matters. No person should have to live this way in society. Kimberly's in a danger to herself, and with suicide talk for years and threats to kill others, she is unstable and unpredictable. I was very specific in my reply brief, and I really do not want to relive those experiences. With this protection order in place, I am able to move on in a healthy lifestyle for myself and my son and everyone around me. Judge Flomman simply put an order that mothers to stay away from our minor child until further order of the court. Her attempt to lose after school care for my child, was successful by the current caregivers at the time. To the best of my knowledge, some of them put a no trespassing order on Kimberly. She has no permanent address, as she claims. She cannot be served. She uses her dad's address that has been, mail has been returned thus far. She still has a shotgun. I wish someone would make sure she is not in possession of a deadly firearm. Again, thank you for the current protection order. My home is at peace with minimal setbacks caused by Kimberly. With a protection order in place, her attempts of parental alienation are no longer a major issue. It's astonishing that Kimberly is a licensed attorney and feels she does not have to obey the law or any order given by a judge. Her appeal and lies keep on growing, and she can't keep up with her own untruths. As she just mentioned, that she claims I hit my son's hand, but on record in motions, she wrote that I grabbed his hoodie and knocked him to the ground. These are just total untruths. The emotional and mental damage done to our minor child is irreparable, and I'm attempting to repair the damage with the help of therapy, in school and out of school, a strong, loving Jewish community, friends, family, and a positive, loving environment in my own home. It takes minutes to hours to tell a lie and seconds to tell the truth. This protection order is to stay protected from someone who is unpredictable and does what she wants whenever she wants to, even if there are court orders that states otherwise. I have shown in my reply brief that there's an obvious pattern of harassment, stalking, and controlling behavior. Kimberly has shown through these patterns that she's above the law and does not have to follow court orders. I respectfully ask this honorable court to affirm the current issuance of this protection order. Thank you, Your Honors.
Thank you. All right, Ms. Edelstein, you have 2 minutes remaining.
Thank you. I'd like to point out that I provided 11 instances, which was undisputed by Elliot, where he lied to the court and law enforcement. And on the record, when I presented that to Judge Flotman, she said it doesn't matter to him. Okay, he's been essentially allowed to lie throughout the lower court proceedings. He just lied here because grabbing the hoodie occurred at his apartment, hitting my son's hand occurred at the JCC. I am not lying, okay? I am the victim of a narcissist who I was married to for 20 years and who abused me regularly. This narcissistic abuse continues today. This man is a disgrace to Judaism. He wears a yarmulke to his work to get out of Sabbath working, but violates the Sabbath. This man has done nothing but lie and avoid accountability, and he has used this court, he has used the process and a judge that's sympathetic to him for various reasons to abuse me, okay, and ruin my career. I have tried multiple times to settle the case with him, including offering to settle with him and give him a payout from my large federal verdict to leave me alone. And he refuses to do that, opting instead to ask the judge to put me away for jail for 6 months for contempt orders. Okay, this is ridiculous. He's trying to destroy my career, destroy my reputation, and this is just more of this narcissistic abuse that I've suffered from this man. He is a menace, okay, and I am free from him, and that torments him more than anything. And so he has constantly harassed me after this divorce. I mean, not even letting me get a Jewish divorce, which is no skin off of his nose. He could have just signed a piece of paper. So again, this has all been at his instigation, and my concern for my son's well-being, because I lived with this man and I know how abusive he is. My son testified he wants to come home. He's not happy. His father constantly verbally abuses him. It's all in the transcript. I didn't coach my son. He wasn't enmeshed with me. I hadn't seen him for almost a year at that point. So for the judge to say he's of tender age and there's a previous enmeshment is ridiculous. I'm a loving mother. I'm concerned about my son, and I took the appropriate steps, but Judge Flotman ignored my motions, told the clerk to deny the evidence of abuse from the body cam from the sheriff's department. I mean, I'm getting no relief at the trial court. You guys have told her she has continuous jurisdiction. The Supreme Court has told her, but she rules only on his motions in the past 2 years, won't rule on any of mine, says that they have to be held in abeyance, says that she has
Ms. Edelstein, you have about 15 seconds to wrap up.
Thank you. And I would like to point out also that I have evidence that this is all related to my federal verdict, and I'm being retaliated against because of it. And again, this is not before this court, but this is part of the problem that I'm up against. He wants money, and he was promised money. That's why he agreed to take my son after 1.5 years of not wanting my son or not wanting custody, not contacting him. It's because he was promised a big payout. And this
Right. Thank you. Thank you very much for your arguments. We appreciate both of you being here this morning. We will take the matter under submission and issue a timely decision. We wish you both the best. Take care.